they always bring in the lawyers to talk about the scary and depressing parts. So I'm going to talk about the emerging body of law around cybersecurity and really just some of the developments in the law and how we're managing the risk. This is an incredibly this area of the law is in flux. It's an exciting area of the law, and it's something that people have to pay attention to, because I think, and I'm not going to bury the lead here, cybersecurity is becoming increasingly important to the regulators, and we're starting to see litigation around this issue. And so it's something people have I think, been gradually paying more and more attention to, and some recent guidance really emphasize that. So I'm going to start with a little bit of background, just to level set here a bit. As you all know, ERISA is a federal law that governs the retirement plans, pension plans, and the health plans as well that are employer provided. There are state law equivalents to ERISA too. So I'm going to talk about ERISA here, but these concepts would be equally applicable at the state level. And ERISA was designed to protect people's benefits. Congress was mostly worried about mismanagement and theft by employers. And so they created a trust requirement, a requirement that people that handle plan assets have a fidelity bond. So if the money's stolen, they're bonded, there's some way to recoup that. But more importantly, they held people who manage and administer retirement plans out to be fiduciaries, which is the highest standard under the law. And that's true both under federal law and typically under most state and local laws too. The key here, though, from our perspective, is that ERISA says zero about cybersecurity. It's written in 1974, been amended probably every 18 months on average ever since. But they've never dealt with cybersecurity. Congress has never addressed it, at least not yet. But cybersecurity, and in particular cyber theft, has really emerged as a major threat to retirement plans and pension plans. And the law just hasn't caught up. There's a lot of good work being done, as you all probably know, in the private sector to figure out how to prevent theft and prevent fraud and protect people's data. But for a highly regulated industry, the fact that the regulators hadn't until recently addressed cybersecurity was a bit unusual, particularly because there are some gaps in the legal framework. You know, we look at this a lot, and you will see that it's entirely possible that a plan has been administered prudently. Everyone has met their obligations. The service provider has done what they're supposed to do under the contract. The fiduciaries have done what they're supposed to do. However, money is still missing. And there is a big outstanding question about who's liable when that happens. Is it the participant, the employer, service provider? There's a growing recognition that these are very real questions. And that they're going to have to be worked out over time. And that means we're almost certainly going to see the regulatory burden increase over time. The Department of Labor over the past, let's say, 15 years or so has really shifted its regulatory strategy from being one of guidance on the front end to regulation by enforcement on the back end. And we can already see them starting to set the stage for what are almost certainly some oversight and enforcement actions on cybersecurity. So let's kind of dig into the guidance that we've got, because it's a new development that the Department of Labor has decided to kind of weigh in on these topics and start to give fiduciaries and record keepers and participants some information about what their responsibilities are with respect to data and plan assets. So until about a year ago, the Department of Labor hadn't said much on the issues. People have been asking for guidance for a number of years. We have been in there to talk to them. Another number of other people had. And DOL was just considering its options. And then in May of last year, they issued regulations that made it easier to use electronic communications. They basically created a new safe harbor for the default use of electronic delivery. And as part of that rulemaking, which we don't have to get into here, but as part of that rulemaking, in the preamble to the regulation, in other words, the kind of precatory language that explains what the rulemaking does, they took their first real position on cybersecurity, and they said that fiduciaries must take measures reasonably calculated to protect the confidentiality of personal information. That's just language in the preamble, like I said, and it's not necessarily a law, but it's a big deal. It's the first time the Department of Labor had claimed that one's fiduciary duties extend to the security and privacy of participant information. But that guy just kind of flew under the radar and hung out there until about a year later, in April of this year, when the Department of Labor issued what I consider to be a much clearer statement of its position on cybersecurity. And that came in the form of 3 tips and best practices documents. I'll preface this by saying these aren't law. They are the department's musings. Maybe that's too flippant, but it's their opining informally on policies and practices that fiduciaries and others should take, but they're absolutely not law. The law is still to be determined. It's just the Department of Labor's gloss. But that said, these documents do appear to establish some minimum expectations, at least as far as the Department of Labor is concerned. And the key premise here is that fiduciaries have a duty to mitigate cybersecurity risk. That's explicitly stated. It's kind of the first time the Department of Labor has come out and said that, in as plain as day. And that is very consistent with the position they took in the e-delivery regulation that I just mentioned a second ago. Okay, so let's, if we can go to the next slide, we can talk about each of the pieces of guidance. So the first document is really the one I think for purposes of this discussion today is probably the most important for you all. It's the document that provides tips for hiring service providers. And it's really geared at plan fiduciaries and plan sponsors. And it's broken into 2 distinct components. The first is a component that talks about due diligence tips and best practices. And the second, they talk about contracting and some of the things you should consider as a fiduciary. So on the due diligence side, the Department of Labor says, plan sponsors and fiduciaries, there are things you should ask service providers about with regard to their security standards and their practices and policies and their audit results and things like that. You should really look for a service provider that follows recognized standards for information security and uses an outside auditor to review and validate that cybersecurity. And then they said, that a plan can have much more confidence, and that's a direct quote, much more confidence in the service provider systems and security practices if they're backed by an annual audit report verifying information security systems, data availability, processing integrity, stuff like that. So this was a big deal for the department. They then went on to say, as part of your due diligence process, that's how service provider validates its practices and the levels of security standards that are in place. You take a look at the provider's track record in the industry. What public information is out there? Have they ever been sued? Things like that. And you should consider whether the provider has experienced past security breaches and how they responded to that. And then finally, they say you should ask about insurance policies. Does the provider have insurance policies in the event that they are the victim of a cybersecurity breach when using the plan's data, and how will they make the plan whole? So with those due diligence tips and kind of looking at the background of service providers, the department went on to give some tips around how you contract, and they basically said that fiduciaries should be cautious of provisions that limit providers' responsibility for IT security breaches, and they should review those provisions if they exist carefully. And there they gave 4 big tips in reviewing contracts, and that's to one, talk to the provider about requiring a third-party annual audit. specify the provider's obligations to maintain the confidentiality of private information, talk to or include in the contract the provider's obligation to meet local, federal, and state laws when it comes to confidentiality and PII. And then again, DOL went back and talked about insurance and discussions and contractual provisions related to insurance to protect from cyber theft and other security breaches. So that document, I think, is the one that is the most useful for plan sponsors to the extent that any of these are useful. But they did put out, the department did put out two others that I want to make you aware of. The second was a set of cybersecurity best practices. And this was really for record keepers and service providers. And there's a 12-point best practice list. I won't read you the whole thing. You can read that on your own if you're so inclined, but DOL does go on to kind of talk about some of the things record keepers and others should do, using encryption and having access control procedures with respect to confidential information and kind of having all this stuff documented. And this document, these cybersecurity best practices, are really a list of what the Department of Labor might expect to see during a review if they were kind of auditing these providers. And I think they're useful. This document's useful to plan sponsors in that it is something that plan sponsors can ask about. It's a list of the things that record keepers, for example, should consider, and it's helpful for plan sponsors to have that list and be able to ask those questions. As you all know, satisfying your fiduciary duty is and there's a substantive component, but it's largely procedural. And did you engage in a prudent process? Not always did you reach the perfect result. And so if we can ask the right questions and document that process, it's incredibly helpful in shielding ourselves from liability if in litigation and in enforcement actions by a regulator. I will point out that some of this is very sensitive, as you can probably guess. There have been industry efforts for many, many years to try and thread the needle and balance the needs of plan sponsors to understand the security processes in place and the protections in place for PII and other confidential information, balance that need with the need of service providers to keep their processes somewhat secret so that the information doesn't get out to the bad guys, so that you can continue to, so the processes continue to be effective. That balance it's kind of a tightrope to walk, and so there are certainly circumstances where if you're going to want information from a service provider, maybe can't necessarily get it or they're reluctant to provide it, and there's just going to have to be some compromise on both sides there. The third document that I want to summarize, and I'll do this one pretty quickly, it's a set of online security tips. And this one's for participants. And it basically says to participants that you should really be monitoring your accounts. You should have strong passwords. You should beware of phishing scams, all the kind of cybersecurity tips that people normally get for good IT hygiene. Maybe if that's a term, I'll coin that one here. Good IT hygiene. All the kind of things that participants should do to protect themselves from the risk of loss or the risk of their information leaking out. I talk about this document just to note that I think it is somewhat relevant to plan sponsors and service providers, because it does indicate the Department of Labor recognizes that it's not all on a plan fiduciary to protect the participant data. There is there's some onus on participants to protect their accounts, particularly in defined contribution plans. Okay, so I'm going to get into legislation and litigation here in just a second. Let me give you the key takeaways from these guidance documents. At a high level, they're largely consistent with general industry practice. I think our clients have been roughly following them for a long time, and they're made mostly consistent with how service providers have viewed these issues. But they are helpful. They're not unhelpful in kind of understanding your duties, and they do give you kind of a framework for engaging in a prudent process to assess cybersecurity threats and protect plans from them. However, they do also foreshadow some potential future enforcement initiatives from the Department of Labor. And they are almost certainly likely to inform DOL investigations going forward. They don't technically set standards from a legal perspective, but at the same time, it's clearly what the department believes is important from a fiduciary perspective. And so as they investigate people, as they consider whether parties have breached their fiduciary duties, that they will almost certainly look to these documents. And like I mentioned, there is some recognition that participants, at least in defined contribution plans, have some responsibility to protect their data. They have some role to play in this process. Okay, so that's the new cybersecurity guidance. So two other things that I do want to cover in the couple minutes we've got left. One is the litigation that's out there. This is a burgeoning area of litigation. Historically, we have not seen cybersecurity litigation. This is a new thing. However, we have for decades seen litigation against plans and service providers over theft, and so this is really just a new era of that. And we're starting to see in a couple of narrow cases that participants who have suffered losses are making the claim that fiduciaries have breached their duties, by allowing the theft, and I suspect that'll stretch over to the leaking of personally identifiable information at some point. There's one big case out there right now. I think we've gotten a couple of decisions in that big case that have cut the plan sponsor and the service provider's way. These are fairly complex issues, and the big case that's being litigated is one where a participant had an account that was approximately $250,000. It was stolen. The participant sued the plan and the record keeper. The plan sponsor was dismissed from the lawsuit. In 2020, the record keeper recently won a decision. That litigation could still be ongoing, but I think the point here is not the specifics of that case. It's that a participant had their account stolen, they had lost something, and they brought a fiduciary breach claim against basically everybody involved in the plan to try and recover that. And it really highlights that, while that was a theft, presumably a theft, and the authorities are involved, this type of litigation over the breach of people's accounts is likely to continue, particularly as cybersecurity breaches continue. So what do we expect in terms of legislation? Is there anything on the horizon? I'm sure most of you are aware that the states have taken, some states have taken an increasingly aggressive position on the protection of personal information. They're taking it seriously, at least some states, and the state laws are proliferating. At the federal level, there's been a lot of discussion about how federal law should, if it address cybersecurity and the protection of personal data, if at all. There have been discussions about amending ERISA, although those discussions have not progressed very far. I think the Hill is looking at options, including, do we want to require fiduciary insurance for plans that covers cybersecurity breaches? That's still up in the air. In the short term, we're unlikely to see any legislative changes, but maybe in the long term, as we continue to see issues in this space, Congress may feel the need to regulate further. So let me just wrap up and give you the big takeaways here. from the final slide, I think there are a few points. One, the Department of Labor guidance is a good articulation of the DOL views. It may be helpful for ERISA plan fiduciaries, also for public plan fiduciaries to the extent your state and local laws mirror ERISA, but it also foreshadows future enforcement from the Department of Labor. And the litigation is likely to continue. And really, there are some very big unanswered questions there and a lot of uncertainty. So it's a good time for folks to review their policies, their practices, their procedures, and think about proactively how you would respond if your participant data were breached, if it were leaked to the general public.